It's much more simpler than it used to be. We're live. Awesome. I don't want to speak too soon. Okay, all good. I will get started. Good afternoon, everyone. Thank you for coming. I hope everyone's Tuesday is treating them well. My name is Danielle Angelari, and I'm the Executive Director of NAMI Northern Illinois, which is an affiliate of the National Alliance on Mental Illness and the nation's largest grassroots organization dedicated to improving lives of individuals living with mental illness and their families. Our group specifically serves Winnebago, Boone, and surrounding counties in our region. We support those in need through various peer-led support groups. We educate families in our community. We advocate by helping to shape public policy and programming for people living with mental illness. We lead many awareness events to actively encourage understanding and provide the tools necessary to improve response to mental illness for all. Today, I'd like to introduce you to Kira and Sarah. Kira Devon is a staff attorney and program coordinator for the Justice, Equity, and Opportunity Program. She has dedicated over 8 years to working at Prairie State Legal Services to help community members defending against wrongful evictions, obtaining needed repairs to rental units, and giving people a second chance by expunging and sealing old criminal records. Sarah Davis is an AmeriCorps Vista member working with Prairie State Legal Services. Starting in July 2021, she has pledged to help empower individuals to break the cycle of poverty by connecting them to legal aid, legal information, and legal education through Prairie State. Kira and Sarah will provide information on their no-cost civil legal help, preventing an eviction as a tenant, fair housing rights, and how to overcome barriers to obtaining stable housing when living with a mental illness. Funding for this programming is provided in whole or in part by the Illinois Criminal Justice Information Authority. If you do have any questions throughout the presentation, please feel free to use the chat box, and I believe we'll facilitate them as they come. Again, thank you so much for joining us, and especially to you two ladies. The floor is yours.
Thanks, Danielle. So in today's presentation, we're going to cover 4 topics. We're going to do an overview of Prairie State Services, then move on to housing inequality and stability. Next, talk about reasonable accommodations and modifications, and then eviction and some final information on how to contact Prairie State Legal Services. And just one thing to keep in mind as you type in questions into the chat, in this setting where we're talking to a group, we can provide legal information, but if there's a legal advice question where someone wants to know if they can get legal help or if their friend or family member can get legal help, that would be something where you contact us one-on-one. So I'm going to talk about Prairie State Legal Services in general first, and Prairie State's mission is to provide equal access to justice and fair treatment under the law. And what that means is that we help people for no cost, so there's never any cost for people to talk to us, or if we represent them in court, there's never any cost for us to be someone's attorney. And we can give people advice, we can represent them at hearings and in court, and everything in between potentially. And our office covers 6 counties out of the Rockford office. So we cover Winnebago, Boone, Stevenson, Carroll, Joe Davies, and Ogle County. And then Prairie State as a whole has 11 offices in Northern Illinois that serves 36 counties. So that's where our Prairie State is focused on, Northern Illinois. And if someone has a legal issue outside of our service area in Illinois, if it's in Cook County, there are a number of organizations there that provide free legal services. And then in Southern Illinois, Land of Lincoln Legal Aid is the main free civil legal services provider there. And our Rockford office is located at 303 North Main Street. It's right across from the Coronado, and it's the same building as Supply Corps. We're on the 6th floor. Our office still has limited availability to the public, so the best way to reach us is by calling us or attending an outreach event where we will be on site to provide legal assistance. For example, we have a monthly event at the Rockford Public Library where people can make appointments or walk in and ask for legal help. And to see if someone can get our free legal assistance, what they would want to do is contact us and tell us a little bit about themselves and their legal issue. We have a variety of grants that let us help people, and those change from time to time. So sometimes we're able to help people no matter what their income level is, depending on their legal issue. And sometimes we're more limited to helping people who are low income with a particular legal problem. And some examples of this: for our domestic violence grant, we have no income limit. So if someone's the victim of abuse and say they want help with an order of protection or divorce because of that situation, we have no income limit to be able to talk to them and give them advice. The same is true for our fair housing grant. If someone's facing housing discrimination, there's no income limit. And then a number of grants that we have allow us to help people with higher income limits, like the one that I'm working on now that's focused on racial equity throughout Prairie State service area. We have a higher income limit. So if someone wants to see if they can get our free legal help, the best way to figure out if we can do that is to contact us. And in terms of issues that we can help with, we help with civil legal services. And that means that we do not do criminal defense where someone has a pending criminal case. That's one type of case we don't do. But then other issues that are in court besides criminal defense cases would often be civil cases. And that's where we would come in. And in civil cases, there's no automatic right to an attorney the way there is in criminal cases. So that's really why Prairie State exists, is to fill that gap where people aren't able to afford an attorney and they still need help with important legal issues. And some of the common legal issues that we help with are helping domestic violence victims get orders of protection, a divorce, deal with housing issues. We can help with public benefits problems, like the loss or denial of food stamps, TANF, Medicare, Medicaid. We can help seniors who are facing abuse or financial exploitation. We can help defend tenants against wrongful eviction or illegal lockouts or habitability problems. We can also help people deal with utility disconnections or denials. We can provide advice related to Social Security cases. We can help people who are facing debt collection issues or wage garnishments. And we can also help with sealing and expunging criminal records after the criminal case is completely over and there was already a decision. And there are certain types of cases that we're just not allowed to do. And some of the common cases are the criminal defense, where there's a pending case. Workman's compensation and personal injury cases are common cases that we don't handle. So you'd want to look for an attorney outside of Prairie State for those. And the way to apply for our free legal help and see if you can talk to an attorney and get an attorney to represent you in court if there's an issue in court is to call us or apply online through illinoislegalaid.org. And illinoislegalaid.org has a lot of good, helpful, free information. If you call us, you'll want to call during business hours, and we have telephone attorneys whose job it is to just answer those phone calls and talk to you, and then filter you to the correct attorney in the office where your legal issue is located. And if you apply online, you fill out the online application, and then there's a number you call at the end, but it's a way to get through a lot quicker than just calling the main number. And that is the information I have about the overview of Prairie State. So I'm going to turn it over to Sarah to talk about housing inequality and stability.
And I just want to make sure first that, did anyone have any questions on that section at all? I know it's relatively short, but. Can everyone hear me okay?
Yes.
Okay. I just wanted to make sure there weren't any questions, but I can move on to the next part. So in this section, I'm going to cover 4 things you should know about renters' rights, specifically pertaining to housing inequality and achieving stability. So first, I'm going to go over why a written lease protects your rights. So a lease can be written or oral. Oral leases are usually month to month, and therefore they can offer less protection, whereas a written lease is usually for a specific term and therefore offers more protection. When you are signing a written lease with a landlord, it should include the full name and address of the landlord, names of everyone who will be living in the unit, how much rent is owed and what day it is paid, as well as where to send it, any late fees, who pays for utility and maintenance, and if pets are allowed. Do keep in mind that when you're discussing the day that rent is paid, you can't assume that there's always a grace period. So for example, if your rent is due on the 1st of every month, but you receive a social security check on the 3rd, make sure to discuss this with your landlord first before signing the lease so you don't encounter any late fees or eviction warnings. And if any changes are made to the lease and they're agreed upon between you and the landlord, make sure those are reflected in writing as well before signing. You should also keep all expenses in mind before moving in. A few things to consider is to look for a place that has affordable rent. 30% of your income is the ideal goal, but that is kind of a perfect world scenario, and at least in our day and age, it isn't always realistically possible. But that being said, that's what makes considering all the other expenses even more important. So if you pay for water, sewer, or any other utilities, try to estimate the monthly cost before agreeing to move in. If you're unsure of how much a utility will cost or if it fluctuates, try to always overestimate when calculating if a place is affordable. You want to keep the time of year in mind for electricity and gas, since electricity will be higher in the summer if you have air conditioning and gas higher in the winter for heat. You can talk to people in your area, family and friends, or even search average utility costs online for whatever area you live in. It's also important to figure in things like the cost of groceries, any medications you're on, and any other necessities when deciding if a place is affordable, especially for those of us living with mental illness. Figuring all of this in may help you avoid a situation where you're struggling to pay for like rent or a utility or a very vital medication that you need. And Kira, do we have any questions that you wanted to field so far?
No, I don't see any questions.
Perfect. So I will just move right along. So everyone under Illinois has a right to livable housing. So you have a right to request repairs from your landlord for problems that occur in the unit or home. If something breaks within your unit, such as you lose hot water, you have no heat, there's a drip coming out of your sink, the first thing you want to do is contact the landlord, manager, or owner, and then follow up with a letter or an email. You want to ask them to fix the problem by a set date. For serious issues, like no hot water, no heat, and no power, they may require a quicker response than minor issues. But even if an issue seems minor, it's still important to contact your landlord regardless. For example, a minor drip from a sink can turn into something major in very little time and could lead to water damage or even mold. And if your landlord or housing provider isn't aware of that, then you could be held responsible for the damages that occur. So what happens if you let your landlord know that a repair needs to be made and they either refuse to make the repairs or they're unresponsive to your request? The first step you want to do is to contact your local health department or property code inspectors and report the problem. From there, make sure to keep track of all contact you have with landlords, inspectors, maintenance, and anyone else about the problem. And then once it's resolved, be willing to allow the landlord or maintenance in to make repairs. Most importantly, there's a very common misconception where if your landlord isn't making repairs, you can withhold your rent. Do not do that. Withholding your rent is a very slippery slope that can very quickly lead to an eviction notice. So it's always important to continue paying your rent while you wait for a repair to be made. And then the last slide for this section is I want to go over the rights that you have as a victim of domestic violence, dating violence, or stalking. You have rights in both private housing and public housing as a victim, thanks to the Safe Homes Act and the Violence Against Women's Act. Up on this slide right now are just a few ways that both acts can help you as a victim, and I'm going to go over two real life examples for you guys to show you how they work. So first, for the Safe Homes Act, we're going to look at a woman who was forcibly detained in her house by her abuser for weeks. He steals her sources of income, like her SNAP money, and she loses her job. She's unable to pay her rent in her Section 8 house, which is owned by a private landlord. Eventually, there is police involvement, and she leaves the house due to the immediate and severe danger caused by the abuser knowing where she lives. She uses the Safe Homes Act notice to tell her landlord in writing that she is left within 3 days of moving out. Later, the housing authority sends her a notice to terminate her Section 8, since according to the landlord, she violated the lease and owes rent. But once it is explained at a hearing with the housing authority what happened, thanks to the Safe Homes Act, her termination notice is overturned, and she is able to move in with her Section 8. In our other example, a woman who was abused for years by her partner is being denied subsidized housing because she was convicted of domestic battery. In reality, she was the victim. She was being strangled and fought back to keep the abuser from killing her, and a neighbor who heard the disturbance called the cops. When the cops showed up, the abuser had blood on him from her fighting back to keep from being murdered. The cops arrested her and charged her with domestic battery based on the evidence that they unfortunately misconstrued. She took a guilty plea, which is extremely common for anyone charged with crime to do, and her criminal record now shows that she was convicted of domestic battery. But at a hearing with the housing authority, she explains what happened, and thanks to the Violence Against Women Act, her denial from subsidized housing is overturned, and she is able to get housing assistance again. So those are just two examples of how these amazing acts can help protect you as a victim. And if there's any questions on this or any of the previous sections, Kira, let me know. If not, we'll be moving on to reasonable accommodations and modifications.
There weren't any questions on these topics.
All right, sounds good. So first in this section, I'm going to go over what counts as a disability in the eyes of the law, and then we're going to look at requesting reasonable accommodations in housing, and then requesting reasonable modifications. So first, a disability is defined as a physical or mental impairment which substantially limits one or more major life activities. Major life activities include functions like caring for yourself, walking, eating, thinking and concentrating, and living independently without relapse, among other things. And a substantial limit means you cannot do the activity at all or only with major restrictions. In order to be classed as a disability, it requires a permanent or long-term effect. A wide range of conditions are considered both physical and mental disabilities, some of which we may not initially perceive as such, like migraine headaches. This slide just shows a few examples, and there are many more. So a physical disability is any medical disorder or condition affecting any body system, such as AIDS, alcoholism, diabetes, speech or hearing impediments, migraine headaches, and paralysis. Whereas a mental disability is any mental or psychological disorder like Down syndrome, depression, bipolar, schizophrenia, PTSD, or learning disabilities. So if you do have a disability, you can request changes or exceptions to rules, policies, practices, or services from your housing provider, so long as they are necessary and reasonable. And that's what we call a reasonable accommodation. Requesting an accommodation will start an interactive process between you and your housing provider. And by law, housing providers do have to participate in this process, even if the initial request is not completely reasonable to them or legitimacy is doubted. So there are a few steps to this process. Step one is to make sure the housing provider is made aware of the tenant's disability, and then it will be determined that an accommodation is necessary to lessen the effects. The tenant will submit an accommodation request, at which point an interactive process will begin. If all goes well, the accommodation will be deemed reasonable and it will be seen that there is no direct threat, and then it will be agreed upon and put into practice. If an accommodation can't be agreed upon right away, then the interactive process will restart until one can be reached. So here I'm going to go over an example of requesting an accommodation for mental health. So here we have Jane, and she has bipolar disorder. She experiences intense mania followed by long bouts of depression. Her depressive symptoms keep her from caring for herself and interacting with others, which leaves her with extreme loneliness and a lack of motivation. Her psychiatrist recommends an emotional support animal to ease her symptoms. Since Jane's apartment complex does not allow pets, he writes her a prescription to present to her landlord. Jane presents the prescription to her landlord along with a letter requesting exception from the no pets policy. Through an interactive process, it is determined that an emotional support animal is reasonable for the landlord and necessary for Jane's mental health. And now, with a reasonable accommodation in place, Jane is able to keep an emotional support cat in her apartment. Caring for the cat motivates Jane to care for herself, and the companionship decreases her loneliness. And in this case, an emotional support animal isn't just there to help with Jane's depression. Having a pet that relies on her will help her think and act more rationally during manic episodes as well. So along the same vein, if you have a disability, you can also request a reasonable modification. These are physical changes to the property, and just like the accommodations, as long as they are necessary and reasonable, you can put in a request. The tenant requirements for this one are a little different. You have to get permission before making any changes and ensure that the work will be done professionally and acquire any permits that may be required. The tenant also has to agree to restore their unit to the original condition before moving out, unless the change will not affect the next tenant's use. And usually for modifications, the requester pays, although sometimes a federally funded housing provider will pay for a modification. One example of this, as you see in the image, is say we have a tenant is paralyzed from the waist down, and the bathroom door in the unit is too narrow for the wheelchair to comfortably fit through. They can request the doorway to be widened as a reasonable modification. And this modification probably won't need to be undone at the end of the lease, as a wider bathroom door will not impact the next tenant. However, if the modification was the addition of a ramp in the unit or somewhere else in the building, then the ramp would need to be removed upon the termination of the lease. And do keep in mind that reasonable modifications aren't just for people with physical disabilities. For example, if a tenant who's living with depression finds that the dark color of their bedroom walls is negatively impacting their mental state, they could even request a reasonable modification to repaint the walls a lighter color. And that actually brings us to the end of this section. So if there are no further questions, I will pass it on to Kira for our section on evictions.
Okay, thank you.
Mhm.
So I'm going to do a brief overview of evictions, which is its own very long topic. So I'm just going to touch on like a few key things here. I'll talk about the types of notice in an eviction, the timeline, and then the difference between private rental housing where someone's paying the full rent and subsidized housing where someone's paying a portion of their income, and also rental assistance. So starting with the types of eviction notices, there are multiple eviction notices someone could get depending on what their landlord says is going wrong in the landlord-tenant relationship. One type of notice would be a notice for non-payment of rent, where the landlord says the rent is past due, and the landlord could give a past due rent notice the first day after rent was due. So if it's rent is due on the first and it's not paid on the second, the landlord could give an eviction notice on the second. And in private housing, which means someone is paying the full rent on their own, it doesn't have housing assistance from like the housing authority or another government program, then the notice would usually be a 5-day notice saying that the tenant has 5 days to pay the rent, move out, or the landlord could file an eviction case in court. If someone lives in subsidized housing where they pay a portion of their rent based off of their income, which would be with the housing authority or in a building that accepts some sort of housing assistance, then the notice might be a 14-day notice or a 30-day notice. And theoretically, it should be a 30-day notice in subsidized housing right now because of the COVID-related rules, but some people might still be getting a 14-day notice as well. And it's the same idea as a 5-day notice where the person has 14 or 30 days to pay the rent that they owe, move out, or the landlord or housing authority could file an eviction case. So that's the type of notice that would cover non-payment of rent. And if someone actually owes rent money and they get a notice, a 5-day notice, 14-day or 30-day for non-payment of rent, their legal options would be to pay the full rent owed and make sure to keep a receipt and pay it within the timeline on the notice. They could pay what they think they actually owe, also keep a receipt and pay within the timeline in the notice, or not pay anything. Also, they could move out if they voluntarily wanted to move out. If someone pays the full amount they owe when they get a notice for non-payment of rent, then the landlord should not be able to go forward with an eviction case and they should stay in their unit. If they pay part of the rent that they think they actually owe, like if they think the landlord got the calculation wrong, the landlord might still file an eviction case in court, and the tenant who rents the unit would have to go to court and possibly have a trial where they explain to a judge that they didn't do anything wrong and they paid their rent, and then the judge would decide what happens in that case. If they don't pay anything and don't have any other legal defense to not paying anything, the landlord could file an eviction case in court. They could ask for a trial, and if there's some other reason they didn't pay rent that is a legitimate basis for not paying rent, then they could see what the judge's decision will be after trial on if there's an eviction order against them or not. And if they move out, then there should be no eviction case filed as long as they move within the time before the landlord files an eviction case in court. So that's non-payment of rent notices. If there's another issue that's not related to rent, like an alleged lease violation, then that would be a different type of notice, which is a 10-day notice normally. And a 10-day notice is one where the landlord is claiming that the tenant violated the lease in some way. It could be a really serious issue, like they committed a serious drug crime on the property and were arrested and convicted of that crime. Or it could be something that seems more minor, like a repeated noise violation where their neighbor is claiming that they're say playing music at all hours of the night. Whatever the alleged lease violation is, the landlord is supposed to give a 10-day notice if they are trying to evict someone for breaking the lease. And the notice should say what part of the lease was broken. So if it was because they're too loud, the notice should say like what part of the lease that comes from. And in the case of a 10-day notice, there's normally no right to fix the situation outside of Cook County. So where we live in Illinois, there's no automatic right to fix it. So the tenant's options would be to either move out voluntarily within that 10-day period, stay, and if they decide to stay, the landlord might file an eviction case in court, and then the tenant could ask for a trial and fight the case in court and explain why they didn't violate the lease. Those are the main types of notices. And also right now, it might be more common that landlords the lease may be expired a long time ago. Since during the COVID time period, there was the long eviction moratorium. So there might be more expired leases than there normally are, where someone had an initial lease for a year, maybe in the middle of that, COVID happened, so they've been there without a lease, and maybe their lease renewed month to month because they were paying rent every month, but they didn't have any new agreement they signed. And so if someone's on a month-to-month lease or their lease is coming to an end, the landlord could give a 30-day notice saying that they don't want to renew their lease. And if they give a 30-day notice saying the lease is over, the options would be the same as a 10-day notice, like either move or don't move. And if someone stays after their lease is over and there's an eviction case filed in court, they would again ask for a trial. And if they had a reason why they shouldn't be evicted, they could present that to the judge. Some common reasons why ending a lease might not be allowed could be if it was discrimination, like if they're actually trying to evict someone because they don't want to deal with, say, their disability and their reasonable accommodation request. That could be a reason why the landlord wasn't allowed to end the lease. So those are the main types of notices. And the first step, if a landlord wants to try to evict someone and says they should leave their apartment or house, is to give that notice. Then after they give that notice and the time is over, the 5, 10, or 30 day, then the landlord could file a case in eviction court if the person hasn't moved out and they want to ask for a court order to evict them. When the landlord files an eviction case in court, they have to try to serve the tenant with a summons that has the court date information, like the case number, the day of the first court date, and how to respond to the eviction. And at the first court date, the tenant could show up to the court date, or if the tenant could also not show up. If the tenant doesn't show up to the first court date and they got the summons served on them properly, then there'll usually be a default order entered for an eviction, meaning the judge will order an eviction because they aren't present, but they knew about the case. If someone is in court on the first court date, they could ask for a trial, they could ask for eviction mediation, they could ask for court-based rental assistance or time to get rental assistance. And depending on what the judge thinks of the situation, there might be a trial date set, or there might be a court date set to give them time to get rental assistance or do mediation. Hopefully, if possible, it's best to get things worked out before a trial date, because anytime there's a trial, a judge is deciding what will happen, and it could go either way. Even if someone has really good evidence, the judge is making a decision and someone could win or lose, meaning they could be evicted or not evicted. If someone wins their eviction case, then they will not be evicted based on that case. If someone loses their eviction case, then there'll be an order that allows the sheriff to come out and evict them, meaning that someone's belongings and the people who live there can be removed from the unit by the sheriff. So that's the eviction court process. And in terms of private housing versus subsidized housing, that comes into play a lot for eviction defenses. So if someone's being evicted and they live in subsidized housing like public housing or Section 8 or other senior low income housing where they pay rent based off of their income, then they might have additional defenses in court. An example of this would be if someone lives in public housing and they got a notice that they're late on their rent, then they should have the opportunity usually to enter into a repayment agreement where they pay a reasonable amount of money every month and they stay in their unit. But if someone lives in private housing where they pay a private landlord full rent, then that's usually not an option. Also, Sarah talked earlier about the domestic violence protections, and those are different depending on if someone lives in rental housing that's subsidized, like public housing, or private housing with full rent. So if someone lives in public housing, for example, and they're facing an eviction, and the issue is actually the result of being a domestic violence victim, they could ask for an emergency transfer under VAWA to another unit to stay safe and prevent the eviction. If someone lives in private housing where they pay the full rent, the landlord would have to let them out of the lease to move, but there's not the same emergency transfer policy for a landlord who it's just like a private landlord with a business. And moving on to rental assistance. Right now, there are a lot of forms of rental assistance. There's court-based rental assistance. There's rental assistance that is going through the city, and there's also state of Illinois rental assistance. So if someone is behind on their rent, they should look into all those different sources of rental assistance to see if there's anything they're eligible for to try to prevent an eviction and then hopefully like move forward with being able to pay their rent after they dealt with the situation that was causing them to need rental assistance. So that's a brief overview of eviction. I don't know if I see any questions. No, I don't see any questions. So I'll just move on to some final thoughts and how to contact us. There's information on this last slide about different programs that we have. You can always call Prairie State's main number to get through to these different programs. But the idea of all these different phone numbers is that they're a quicker way for particular issues to get through. So for like fair housing, just housing discrimination, calling that fair housing number can be faster because it's like dedicated to that one particular project than calling the main number, but you can always call our main number as well, and then you'll be filtered to the appropriate person depending on which options you select. And that is all the information I have to share. Danielle, are there any questions that you got?
I have not seen any. Everyone, you can feel free to type in the chat box or the Q&A section. And I did see a question about sharing the slides, and if that's fine with you, I'm going to send to the attendee list, as well as maybe those that couldn't make it today.
Yeah.
And I have the recording.
Emailed you the slides.
Thank you.
10 minutes ago.
Thank you. No, I'm not seeing any questions, but I do really appreciate you both for sharing today. We had a good audience, so
Of course.
I'm sure they appreciate it too.
Mm-hmm.
Great. And could we do that poll question real quick as well?
Absolutely. Yep.
So we just have
Thank
one
you.
poll question. If you could answer it, that'd be great. The question is, do you feel you learned something about the law from this presentation? Yes or no? Super easy question.
Thank you for reminding me.
Yeah.
And thank you for having us today and allowing us to present on these topics.
Of course. It's all about the education.
Mhm.
All right, awesome. You got 100% yeses.
Okay, great.
Perfect.
Great. Well, thank you.
Thank you. I hope everyone has a really good day and the rest of your week. Enjoy the fall weather out there.
Thanks. Have a
everyone.
good day.